Chad Daybell receives a new trial date. As you can recall, Chad Daybell was first joined with Lori Vallow for their trial, and then guess what happened? They got severed. Why? Because Chad Daybell wanted a continuance. Why? Because the district attorney kept producing more and more discovery. Lori Vallow said, hey, there was a discovery cutoff date, and we're ready to go, and I'm not waiving speedy trial. So the judge severed their trials. Lori Vallow obviously went to trial and was convicted of all counts. The defense has asked for a new trial based upon some juror misconduct issues, some jury instruction issues, and the fact that, well, the prosecution really messed up the whole charging dates and the statute as it relates to the indictment. So what do we know about Chad Daybell? Well, it looks like he's going to trial on April 1st. That's right, April Fool's Day 2024, Chad Daybell will finally be going to trial. It's set to go through the entire month of April and May. 2 months, ladies and gentlemen. Now, you have to remember, Lori Vallow's trial took 4 weeks, and we didn't even have the sentencing phase as it relates to the death penalty because that was taken off the table by Judge Boyce because the prosecution blundered that whole process. Anyway, this trial will be in front of Judge Boyce once again, and the parties must comply with the court's pre-trial order. Prosecution, let's go ahead and jot down these dates. We're trying to help you. There's a final pretrial conference set on February 22nd, 2024. And the district attorney, please note, please make the following discovery deadlines. Police reports, that's what the discovery is. Police reports, results of interview, and anything that the prosecution has to turn over pursuant to statute and case law, affectionately known as Giglio or Brady material. So that deadline is February 1st, 2024. And as I noted, the court dismissed the death penalty punishment phase for Lori Vallow as a sanction because the prosecution kept turning over discovery late. And the prosecution had been in possession of that information for years. Yeah, that's a problem. So, prosecutor, make sure you get all that discovery. You've had 3 years now. It should be all inventoried, ready to go, so there's no issues in the Chad Daybell case on April 1st of 2024. Juror questionnaires, another thing that the prosecution turned over late. Well, those are due January 5th. And jury instructions are due by the close of business on March 11th, 2024. Practice pointer here for the prosecution. Now that you know that you want to proceed under a different subsection of the statute that you charged in the indictment, as you did in the Lori Vallow case, now may be the time to make that amendment. Just saying. Now you do you, prosecutors, but most of the world didn't think it was a big issue, but for those that kind of know what was going on, it was a huge mistake. Even Judge Boyce was upset and disappointed that the prosecution didn't have their act together. And as you have noted, and we did a show about this, is that the defense kept saying, this doesn't make any sense. Are you sure you're not charging it under another statute? And the prosecution said, we know what we're doing. Apparently, maybe not. Yeah, you got the conviction, but you got dead babies. You're going to get the conviction. Let's face it. Let's admit it. You got dead kids. It's a tough battle for any defendant. And then throw on a wife of somebody, of your new husband. Yeah, doesn't look good. And you throw in all the 404B evidence. Yeah, it's not good for Lori Vallow. But go ahead and prosecutor. Let's get this right. If you're going to amend and you're not sure, you better supersede that indictment now. Like I said, a lot of people didn't think anything of it. I saw a lot of information. Nobody thought, they just amended the date, no big deal. That's a huge deal, ladies and gentlemen, and only in Idaho, apparently can you amend an indictment by a stroke of the pen. We're not talking a little, we forgot, we misspelled a typo, we misspelled a perfunctory word in the indictment. No, you charged the wrong subsection of the statute. Only in Idaho can you make that amendment. You have to go in federal court in any state that I've ever practiced in. You have to go and amend the entire indictment. They almost could have caused the case to be thrown out, to get not guilties, ladies and gentlemen, because the prosecution blundered it. Let's just say, hey, congratulations, they won. But it wasn't for the amount of incompetence that they've shown throughout this entire process. Because, like I said, we talked about the motion for new trial. That included the juror misconduct allegations that he may have viewed some information. I don't think that's going anywhere. What's more interesting is the fact that he made statements and then he said, I watched a news thing later on. I get that. But guess what? You didn't qualify that in the first interview. And the defense, I don't think it's going to get much hay, but it just shows you, jurors, you don't need your 15 minutes of fame. Just move along. Just saying. The other issue was that the law was incorrectly stated, and then obviously the amendment to the indictment that I think they should do. Now, there's been no ruling on any of those issues yet, but obviously if the court were to grant a new trial, Lori Vallow could join then Chad Daybell for that trial, and it would be as if the whole trial didn't start again. The question is, does Judge Boyce want to do a safe thing or just let it ride, so to speak? The easy thing would be for the judge to say, I'm going to stand by all my decisions. I was correct. And if there was error that was made, guess what? It gets reversed on appeal in probably 3 to 5 years. Or he grants a new trial and they do it all over again. And Lori and Chad get to sit there together and, hear all the evidence against them. And then it can be absolutely clear who the conspiracy was between. Obviously, Alex Cox, Lori Vallow, and Chad Daybell. And if the prosecution thinks others were involved, they should probably name them as well. We'll see. I don't think the judge is going to give her a new trial, but now at least we know Chad Daybell will be going to trial in April 1st. Set your calendars, ladies and gentlemen. Prosecutors, docket it. Get it all on your calendar. Make those changes to the indictment if you need to now. Next, pot smokers, they're coming for your guns. Remember that mom who had a 6-year-old and went to school and shot the teacher? Yeah. She now has federal gun charges. So Deja Taylor, the Virginia mom of that 6-year-old boy accused of shooting his elementary school teacher back in January, is facing federal drug and gun charges. An information filed Monday says that Taylor bought a firearm from a gun shop in Grafton, Virginia, back in July of 2022, while she, knowing that she was an unlawful user of controlled substances. The document says that Ms. Taylor made a false written statement when filling out paperwork for a gun purchase at Winfrey Firearms. Taylor indicated she was not an unlawful user or addicted to marijuana or any depressant, stimulant, narcotic, drug, or any other controlled substance, when in fact she knew she was an unlawful user of marijuana. Marijuana is legal in Virginia, but federal law requires prospective gun owners to disclose whether they use federally illegal substances like marijuana. Taylor's attorney, a guy by the name of Mr. Ellison, says that Ms. Taylor planned to enter pleas of guilty to the charge, and they're proceeding by information, which saves the government to have to go and get an indictment. There is also a state case pending, but you want to get the federal case done so that you can keep those criminal history points down low on the federal sentencing guidelines. So once they get the federal stuff done and sentenced, then she'll deal with her state case. And like I said, Taylor's 6-year-old shot and wounded a teacher, a woman by the name of Abigail Zerner, back in Newport News on January 6th. Taylor was charged in April with felony neglect and reckless storage of a firearm. A trial was set for August 15th, but like I said, her attorney says that they're going to reach a plea agreement. Felony neglect charge is punishable by up to 5 years in prison. The misdemeanor charge of recklessly storing a firearm is punishable by up to 1 year in jail. And obviously the young boy will not be prosecuted, although he probably needs some help of some type. Hopefully he's going to get it. All right. So let's talk a little bit more about Kohberger. This guy is a police officer wannabe, and I think he's probably a narcissistic liar. Now, let's face it, I'm not a psychiatrist. I'm just calling it the way I see it, all right? Now, Kohberger apparently bragged of his physical prowess and his skills with a knife, which he claimed that he learned while cutting fish in a job application to become a security guard. This is where he claimed it all. Now, obviously, Bryan Kohberger has not always just spent his life in prison. At one time, he was applying for a job in the Pleasant Valley School District in Pennsylvania, specifically back in 2015. He mentioned in the application his year of youth law enforcement training while he was in high school. So this guy's wanted to be a cop for a long time. And Kohberger claimed in his application that he cut fish to the specifications of customers. Now, his former boss said that he only lasted about 3 weeks on the job, and he never got to the stage where he learned to fillet fish. Now, the murder suspect, Mr. Kohberger, said that he boxed after school every day. And according to this application, Mr. Kohberger also wished to be considered for roles as a janitor or as a courier within the district if the security job didn't come out. He mentions 2 previous roles in his security guard job application, working at the Big Brown Fish and Pay Lakes in 2011 and the meat counter at BJ's Wholesale Club back in 2015. He said he had experience working with his father as a maintenance worker on pipes and air conditioning systems. He bragged that he lost 130 pounds while in high school, crediting boxing and running with the weight loss. And another skill was that he was being an extemporaneous speaker, competitive improvisationalist in public speaking. As it relates to his weight loss, he said that this is proof that he has the required dedication to be successful. We'll have to see how that worked out for him, obviously. Well, he got the job beginning as a casual security guard before being promoted to a part-time security guard. Then in June of 2021, Mr. Kohberger resigned from his role at the school, and he says, "I understand that if I do not resign, I have the right to a school board hearing to determine if I should be dismissed for employment with the school district." Apparently put this in a letter. The exact circumstances regarding his resignation are not known to the public. Mr. Kohberger was also suspended for 1 day without pay because of an issue with his clearance. And then Mr. Kohberger's boss at the Big Brown Fish and Pay Lakes Fish Farm said that the former Washington University student never used a knife while working there for him. He said that when kids came here, their jobs are to keep the place clean, pick up paper all day, help customers catch fish, fix poles, and then when they try to train them how to fillet fish. And if they got good at it, then they can fillet fish, specifically the customer's fish. He said that Kohberger never reached that point because he left the job after only 3 weeks. But I think it's interesting. Look at this picture back in his high school days where he's in the youth program, kind of like a ROTC for police officers, I guess. This guy's wanted to be a cop. And for whatever reason, he can't be a cop. There's something that's not right with this guy where when they screen him out, the psychological evaluation stuff, he is eliminated. I think that's what we're going to learn. I have a friend who just went through the police academy, and they are very rigorous when it comes to the psychological part to make sure that you're a stable person. And it's almost like maybe some guy that couldn't be a cop was going to show the cops that he could get away with something because he's smarter and better than anyone else. I don't know. Let me know what you think in the comments below. So go to CrimeTalkSearch.com. Sign up for that background subscription service today. You'll be happy you did. Take a look at this unsolicited comment that we received. A lady who said, "Oh, I wasn't too sure about this, but guess what? I was looking to have somebody do some work for me, went to CrimeTalkSearch.com, signed up for that background search, and found out that the person that, well, they were going to hire, come into their life, had an extensive criminal history." Take my word for it, ladies and gentlemen. You need to check people out if they're coming into your lives. Get that background search. Find out what kind of criminal history they have. Find out if they're on a public registry. Who knows? It could save your life. Go to CrimeTalkSearch.com. You'll be happy you did. Next, the suspect for the disappearance of Natalee Holloway is coming to America. Just want to play that song, "Coming to America," but not for this particular reason, right? So that's right. The main suspect in the 2005 disappearance of the student, Natalee Holloway, was handed over to U.S. custody and departed Peru on a flight to the United States on Thursday, roughly a month after both countries agreed to his extradition. Vander Sloot is wanted in the U.S. and 1 count each of extortion and wire fraud, only charges to have ever been linked the Dutch citizen to Holloway's disappearance on the Caribbean island of Aruba. Now, Tuesday, his extradition moved forward after a Peruvian judge affirmed the decision to temporarily transfer custody to U.S. authorities. Vander Sloot is serving a 28-year prison sentence for the murder of a Peruvian woman, and authorities over the weekend moved him from a maximum security prison in the Andes to the detention facility in Lima. It's not exactly clear when he would make his first court appearance in the United States, and the United States U.S. Attorney's Office declined to comment on Vander Sloot's departure from Peru. Now, Holloway, who lived in suburban Birmingham, Alabama, was only 18 when she vanished during the trip with classmates to Aruba, and she was last seen leaving a bar with Vander Sloot, who was a student at the international school on the island. Vander Sloot was identified as a suspect and detained weeks later, along with 2 brothers. Now, Holloway's body was never found, and no charges were filed in the case, and a judge later declared Holloway was dead. Now, federal charges filed in Alabama against Vander Sloot stem from the accusation that he tried to extort the Holloway's family in 2010, promising to lead them to her body in exchange for hundreds of thousands of dollars. The grand jury indicted Vander Sloot that year on 1 count each of wire fraud and extortion. Now, in 2012, Vander Sloot pled guilty in Peru to murdering 21-year-old Stephanie Flores, a business student from a prominent Peruvian family. Like I said, she was killed in 2020, 5 years to the day after Holloway's disappearance. Now, a 2001 treaty between Peru and the United States allows a suspect to be temporarily extradited to face trial in the other country. Vander Sloot's attorney, Maximo Altez, initially indicated his client would not challenge the extradition, but then changed his mind Monday when he filed a writ of habeas corpus. A judge ruled against Vander Sloot the following day, and the time that Vander Sloot ends up spending in the United States will be extended until the conclusion of the criminal proceedings here in the United States, including the appeal process, should there be one. The resolution also states that the United States authorities agree to return Vander Sloot to the custody of Peru after the matters are resolved. Now, Vander Sloot married a Peruvian woman in 2014 in a ceremony at a maximum security prison. He was transferred among Peruvian prisoners in response to reports that he enjoyed privileges such as television, internet access, and cell phones, and accusations that he threatened to kill a warden. Nice guy. Nice guy. And who threatens the family to tell where the location is unless you know where the body is? Probably a case that will never be solved in a court of law. The prosecution responds in regards to the motion for a new trial that was filed by the defense in the Lori Vallow matter. It is a lengthy response that the prosecution has filed, and I'm going to cut to the main points of it. As you may recall, the prosecution convicted Lori Vallow, and the defense moved for a new trial. Several grounds were that the prosecution was able to amend the indictment at the very last minute, literally 30 minutes before they rested their case, that the judge gave some incorrect jury instructions, and then also finally that there was alleged juror misconduct. Needless to say, the prosecution thinks those arguments are wrong, frivolous, and that the court should promptly deny the motions. So let's see what they have to say. First, just for background, on May 25th, the defendant filed a motion for a new trial, and the hearing has been set for June 15th of 2023. So that's coming up next week. The prosecution argues that neither the statute nor the rule prohibit the grant of a new trial on grounds not argued by the defendant, so long as the defendant has requested a new trial and the grounds relied upon by the court is one of those specified in the statute. Now, the statute that they're referring to and the rule is the Idaho Criminal Rule 34 and Section 19-2604, which states when a verdict has been rendered against the defendant, the court may, upon his application, grant a new trial in the following cases. First, when the trial has been had in the absence, if the indictment is for a felony. They basically tried somebody in absentia. They don't do that very often. They just issue a warrant for somebody's arrest. When the jury has received any evidence out of others that results from a view of the premises. When the jury has separated without leave of the court after retiring to deliberate upon their verdict, or been guilty of any misconduct by which a fair and due consideration of the case has been prevented. When the verdict has been decided by lot or by any means other than a fair expression of opinion on the part of all jurors, basically not a unanimous jury. And when the court has misdirected the jury in a matter of law, or has erred in the decision of any question of law arising during the course of the trial, and when the verdict is contrary to law or evidence, and when new evidence is discovered material to the defendant, that which could not be reasonably discovered with diligence and produced at the trial. The prosecution wants to argue that, hey, let's take a look at these and see how they don't apply. The first was obviously Lori Vallow was present for a trial. Doesn't apply. The defendant asserts the jury considered evidence not introduced at trial. However, there's nothing to support the defendant's assertion. The jurors remained through the deliberations and verdict. Nothing has been alleged, nor is there any support that the verdict was decided by a lot to the contrary. And each juror answered yes when the verdict was read and they were polled. And the defendant then contends the court misdirected the jury in a matter of law or has erred in the decision of any question of law arising out of the course of the trial. However, the state opposes this assertion. And then the defendant contends that the verdict is contrary to law or evidence, but there's nothing to support that contention. There's no allegation or assertion of any new evidence, and the defendant focuses their argument on a new trial, and the state obviously disagrees. They're arguing sections 2, 5, and 6. So the prosecution then states that higher courts in Idaho have clearly established that any variance regarding the named co-conspirators or number of co-conspirators is not a material variance, since the burden with the conspiracy is to prove only that the defendant conspired with at least one other person, not to prove an agreement between all named conspirators or even the identity of the other co-conspirators. Remember, they said, hey, you charged all these people in this conspiracy, and then you got the trial and basically said it was just a conspiracy between Alex Cox and Lori Vallow, when in your indictment you said it was up to 5 people. Shouldn't have done that. Prosecutor says, hey, we only had to show there's a conspiracy between 2 or more people. That's all they had to do. And the prosecution says, hey, you were on proper notice of any of the charges against you. That's kind of the standard argument prosecutors make. You were on notice. You're on notice. Anyway, the rules state that the court may permit amendment of a complaint, an information, or indictment at the time before the prosecution rests if no additional or different offense is charged and if substantial rights of the defendant are not prejudiced. Right? Read what's the significance of that there, ladies and gentlemen? The complaint or information at any time can be amended if no additional or different offense is charged. Now, of all of the arguments that the defense made, I still think this is the strongest. The judge let them change that. But when you're changing a different subsection of the statute, how is that not another offense? It is. So, anyway, the prosecutor says, hey, we did an indictment, but the information can be amended without leave of the court, which is just simply permission, at any time before the defendant pleads. Well, obviously that didn't take place. At any time thereafter, in the discretion of the court, where it can be done without prejudice to the substantial rights of the defendant. Okay, you're in trial. And listen, I'd be surprised if Judge Boyce grants the defense motion in any way. This is probably the best argument. But the judge already granted it, so he's going to make it look like he's wrong. Now, the only way the judge could do this is, you know what? Maybe I was wrong. I shouldn't have done it. I was upset. The prosecution, this was not a small clerical error. It's a different statute. And the fact that you guys didn't figure this out in 2 years since you indicted them, that's on you. Too bad, so sad. I'm going to grant a new trial, and guess what? We'll go do it with Chad Daybell on April 1st. I don't think the judge will ultimately do that, but that would be the best case scenario for the defense. I don't think it's going to happen. And so obviously the defense says that the amendment is to count 1, 3, and 7 of the indictment, and counts 3 charges the defendant with conspiracy to commit murder in the first degree. Count 7 charges the defendant with grand theft. In count 7 of the indictment, while the defendant was charged with grand theft pursuant to the Idaho Code, the indictment included the language by deceit and with intent to deprive, which is reflective of the language contained in the statute. The charge of grand theft is the same underlying grand theft referenced by the conspiracy charge in count 1. And once again, the prosecution argues the defense was on notice. But now, as you may recall, throughout these proceedings, the defense kept saying, this doesn't make sense. What statute and what subsection are you applying it on? And the prosecution kept saying, you've received a discovery, you have the indictment, that's what we're relying upon. And then somebody, some genius, right before they closed said, oh my gosh, we didn't charge the right statute, the wrong subsection. Oh my goodness. That's why I think it's the best argument for the defense. Makes the prosecution look not so great. Makes them look, frankly, a little bit incompetent, even though they got a conviction, which lots of things were going in there. But that's the gist of their argument. And the state ultimately concedes that, hey, while the indictment in this case wasn't amended until just before the close of the state's case, the defendant was on notice of the grand theft, was being prosecuted on a theory of theft by deception, and that the grand theft was the basis of the conspiracy to commit first-degree murder and grand theft. Hey, prosecutors, and here's going to be the simple thing to see if they're being disingenuous. In Chad Daybell's case, are they going to amend his indictment, or are they going to do the same thing all over again? And if they move to amend it, it shows that they got it wrong in Lori Vallow's case. Just something to think about. And next, the prosecution says the instructions weren't confusing, and the jurors considered the evidence, and there's no basis whatsoever that there was juror misconduct. Frankly, I think that's the least best argument that the defense has in this particular case. And like I said, I think the court will more than likely deny all of those motions. But we wanted to bring you the government's argument so you could hear it for yourself and see if it makes sense. Let me know if it makes sense.